Currell Limited.
Yes, that's right.
My lords, my lady. I'll start with a summary of the respondent's position and then set out the structure of what's going to be the rest of my submissions. The revenue have advanced 4 grounds of appeal, and there are multiple sub-issues we're going to have to deal with. Really just 2 questions applying to 2 transactions. Transactions being, first, the company, i.e. the employer, paid £800,000 to a third party, being the trustee of the EBT. Second, the third party, that's the trustee, then advanced a loan to Mr. Currell, who was one of the employees of the company by virtue of being a director. In due course, we will discuss what happened to the money afterwards, but those are the key transactions. And those 2 transactions were planned, pre-wired, said the first tier, as was my submission before the first tier. And the 2 overall issues are, is the payment to the trust a payment of earnings within section 62.2? Second, was the loan from the trustee to Mr. Currell a payment of earnings in section 62.2? NIC legislation is slightly different. No one is suggesting it creates a difference in this case. And in particular, HMRC will on 62.2a and c. There are no other issues. In particular, HMRC are not arguing for a benefit in kind on the foregone interest on the loan, because they accept there are specific exemptions that apply to these transactions where you've bought shares. And there are no corporation tax issues. The primary reason for that is the company did not claim a corporation tax deduction for the payment in the EBT, which of course is entirely consistent with the employment tax position, i.e. if there's no employment tax charge, then there's no CT deduction. But also, HMRC have chosen not to argue for a deemed CT charge under the loans to participators regime, which, if we have time, we'll come to later. And that's a choice they've made, even though, in response to questions yesterday, HMRC submitted that the purpose of the payment was to prevent the Section 455 charge arising. And the determinative factual findings made by the first tier, or perhaps absence of factual findings, are, first, the tribunal accepted...
Mr. Elliott, I'm sorry to interrupt you, but I'm not as fast a typist as perhaps some people are.
I'm sorry.
If you want me to follow your submissions, then I'm afraid you are going to have to go a bit more slowly.
I will slow down, of course, my lord. So the determinative factual findings made by the first tier, or perhaps absence of factual findings, are first, the tribunal accepted my primary submission on the facts, that the purpose of the payment to the trust was to make the loan of £800,000 to Mr. Currell. It rejected HMRC's submission that this was a straightforward application of ranges, and it declined to make a primary finding that the payment to the trust was Mr. Currell's remuneration. It was not his salary, it was not a bonus, it was not a reward for his services.
Sorry, just pausing there. Can you just repeat that? You're saying the tribunal was invited by HMRC to find that the payment was straight remuneration. Well,
yes, that it was a reward for services.
Mr. Ghosh obviously says that that's what they did find, but so
not in its primary factual findings.
Just unpack a little more.
Well,
you say the
I'm going to go through
did and didn't find.
Well, we're going to go through the first section of my submissions is going to go through the actual findings by the first tier.
Right.
And nowhere in those findings is a primary finding of facts that the payment was a reward for services. The only place you see that mentioned is in paragraph 57, as a consequence of the error of law. That's a conclusion. But it's not in the section headed primary factual findings, and it's not in any of the sections looking, for example, at the purpose. I'll take you through those findings. And we say that's critical. They rejected that. Because if the tribunal had accepted, as HMRC submitted for the first in before you, this is a straightforward application of ranges, it would have been a very short decision. If the payment into the trust is remuneration, that's taxable. That's Rangers Supreme Court. It didn't. That's why it had to do the much longer analysis, which we're going to look at, which contained the error of law.
You may be right about all of that, and I don't want to preempt anything because I have no view concluded or other about which way this is all going to go. But suppose you're right about that. What Mr. Ghosh says is that, correctly analysed, this is a pure Rangers case. So at some point you will have to address that.
My lord, may I ask you to hold that thought for about 3 minutes, and we will come to what I say this case is actually about, which is the revenue
Right.
submission, which is the argument that because the loan is a reward, therefore that characterises the payment as a reward.
Yes,
That's the revenue submission.
it is.
That's what the case is about. I'll come into that in just a moment, and that will be the focus of my submissions, because that is their case.
Thank you.
But looking at primary factual findings, it did not find primary factual findings that the payment was a reward for services. Secondly, in relation to the loan, by contrast, the loan was a reward for services, that's the finding, but it was a genuine and repayable loan. The tribunal did not make any findings that there was a common intention the loan would never be repaid, or that it would never be enforced, or that Mr. Currell had control of the trustees of when he repaid.
Sorry, again, can you just slow down a little? You may be coming back to this.
This is a summary, and I will come back to each of these points. This is sort of in outline.
We dive into headline points.
I'm very happy to take it that way. I'm just acutely aware there's a lot of ground to cover today. They didn't make any of those findings. And of course, one of the findings is that part of the loan has been repaid. And our submission it is because of those factual findings that the revenue arguments must fail. Because in order for there to be a payment of earnings under section 62, read with section 18 and the PAYE code, first there has to be an emolument, i.e. a salary, a bonus, remuneration. That amount has to be a reward for services. In addition, because of section 18 the PAYE code, it has to be paid. And of course what Rangers Supreme Court established was that the payment doesn't have to be to the employee, it can be to a third party. Those are the two conditions, emolument, paid.
Can a loan in principle be an emolument? Because what I have in mind is that although it may be a genuine loan, you may have to pay it back, and indeed you may pay it back. But nevertheless, in the meantime, it's been jolly useful for you to have that financial advantage.
That is the subject of what is going to be part 3 of my submissions, because
I
that is the revenue second argument, whether a loan can be earnings and in what circumstances.
But what's your answer in a headline?
In a headline, my primary submission is, wherever the revenue place the threshold, they don't have the facts in this case.
Right.
So that's my first point. However low they place it, they don't have them. So they're not going to win this case. So if you wanted to, you could leave that point, a potentially difficult point of setting a threshold, for a case where it actually matters.
Right.
But the second point is that we do not say that a loan can never be earnings. If you look perhaps at the fact of OCO, where there was a finding that even if the trustee asked for repayment and the employee didn't pay, they wouldn't enforce it. That was a primary factual finding. That might be a situation where the loan is actually earnings. So I'm not asking you to rule that out. And the Upper Tribunal didn't rule it out. The Upper Tribunal's decision is, this loan isn't earnings. If you wish to go down, I'm nervous of using my time on a point I say doesn't arise in this case.
No, I'm certainly not inviting you to. Certainly speaking for myself, I tend to take the view that a court should only decide what it has to.
Well, even if you take, we'll be careful, highest and lowest, the revenue case is lowest in terms of what's necessary, i.e. a finding, I think they went so far as if Mr. Currell had practical control over whether he made the payment, which I know Lady Justice Falk had issue with that submission, but let's say that was they don't have those findings. There's no findings in the first tier for that, even for that very low threshold.
Yeah, well, I understand that, and I certainly don't want to take you out of order.
No, so that will be what's going to hopefully be part 3, albeit that part's a bit elastic. Very happy to take the points, any concerns from the court at any stage. Let me know what is troubling you.
Thank you.
So, emolument paid, 2 conditions. In this case, the payment to the trust of £800,000, it was not an emolument, it was not a reward for services, and it was not intended to be a reward for services. In relation to the loan by the trust, that was a genuine repayable loan. As I've just indicated, the revenues case keeps shifting as to exactly what they're saying, what the threshold is, but whatever threshold they set, they just don't have the factual findings. So the revenue, our case is the revenue do not have the primary factual findings they need. They haven't made an Edwards and Bairstow challenge, and therefore they're stuck with those findings. Now, before I say what this case is about, I'd like to make some points about what this case is not about. First, it is not, and has never been about, whether or not there can only be earnings where there is a prior contractual entitlement. It's never been about for a payment to a third party. That has never been argued. You can see it in recitation of my submissions in 55 of the Upper Tribunal, disavowing any argument that there needs to be a contractual entitlement. And it is not the basis for the Upper Tribunal's decision, albeit the Tribunal did try to grapple with what Lord Hodge meant by entitlement. And we will look at what my submission was and what was accepted when we look at paragraph 127 later on. The question in this case has always been whether the payment to the trust was remuneration, i.e. whether it was a reward for services. That is the point the FTT grappled with and the Upper Tribunal grappled with. If the Tribunal had found that the payment to the trust was Mr. Currell's remuneration, straightforward finding like in Rangers, then that would have been a very short decision. It would have been a straightforward application of Rangers. But it did not find that as a primary fact, and therefore it did the more convoluted analysis we're going to review. Second point, what this case is not about. I think this case is not a dispute about the ratio of Rangers Supreme Court, because everyone agrees the limits of what was decided in that case. Rangers decides that if a payment does constitute remuneration, which was common ground in that case, and if it's made to a third party, that's taxable as earnings. That seems to be agreed. Albeit, I think what the parties might disagree about is the significance of the three factors relied upon by Lord Hodge later in his judgment as to why the payments in that case constituted remuneration. That might be a change. In terms of the ratio, we're all agreed. If you have a reward for a payment which is remuneration or a reward for services, and it's paid to a third party, that's taxable. What we say is important is the revenue want to skirt around and ignore the application section by Lord Hodge, and we say that's potentially important. So, in light of HMRC's submissions yesterday, what has this case become about? Situation. Employer makes a payment to a third party with the intention that the third party provides a benefit to a specific employee. But that payment itself is not a reward for services and is not intended to be a reward. Third party then provides the benefit, which is a reward for services. Those are our facts. And what HMRC say and what they have to argue is that the fact the third party provides a benefit which is a reward for services means you must look backwards to the payment to the third party and find that that payment must be remuneration, i.e. a reward for service itself. That's their submission. So in this case, the payment made by the employer to the trust, and the trust makes the loan, and the loan's the benefit. We'll look at other cases with different facts, potentially, different types of benefits. HMRC say tax the whole payment to the trust, to the third party, i.e. the cost to the employer. You could consider other facts. We're going to come back to some in detail, but I'll put some out now. Say the employer paid £50,000 to a group company, to a subsidiary, to buy a car, which will be leased to a specific employee. Or perhaps the employer pays £1 million to a group company to buy a house so that an executive can live in it for 5 years. HMRC say that where you have a payment to a third party, for the third party to provide a benefit, that automatically characterises the whole payment as earnings, immediately taxable, i.e. the cost to the employer of allowing the third party to provide the benefit. And they cite no authority for that proposition. I will take you to some cases in due course. And we say that is a radical and counterintuitive submission. Take a case like this. Employee receives a loan from a trust for 1 year, 2 years, 5 years, and then they repay. Yet HMRC say that they are taxed on the full £800,000 as if it was their earnings, even though it provides them with no lasting benefit. All the employee gets is a temporary loan and nothing more. Take the house example. The employer is setting up a new office in Manchester, transfers £1 million to another group company to buy a house, specifically for the new general manager of that office, who has agreed to relocate, so this is an incentive for them to relocate. And they are then licensed by the group company to live there for 1 year, 2 year, 5 years. HMRC would say, yes, you only get a specific benefit, i.e. the use of the accommodation for however many years. And yes, there is a specific regime that taxes benefits like that in the benefits code. But we are going to treat the whole £1 million paid to the subsidiary as if it's earnings, immediately taxable, i.e. deductible, of course, from the employee's pay. The burden on them and an employee on the company, on the employer. Even though it's only being paid to provide the employee with a specific benefit. That is the approach HMRC asks you to accept in this case. And of course, what that does is it creates surprising distinctions, and we'll explore these. But what HMRC say it does is it creates fundamental distinctions in taxation between the ways in which the same benefit might be provided, only because the employer decides to make a payment to a third, and have the third party provide the benefit. So going back to the house example I just made, if the employer decided to buy the house themselves and then let the executive live there, revenue say, oh, don't worry about that, tax the benefit. But because there's a payment first to the third party, you tax the full payment.
Is it the presence in the tax legislation of the benefits code that gives rise to your analysis, or is that adventitious?
So we say you tax the benefit according to the rules that apply to the benefit.
Right.
So that might be under a number of provisions. So for example, say you had a Heaton and Bell situation. Heaton and Bell was a provision of a car, but there was a right for the employee actually to give up the salary sacrifice and get the full money back. Tax treatment of the benefit, therefore the car, was that you still tax the full amount. So you still tax the sort of annual amount that they were giving up. So you just apply the normal rules. That's under the earnings. Yeah, that's under section 62.
I just wonder if my Lord's question might be answered better by noting that the benefit code is not comprehensive. So, for example, in your house example, there are certain cases, caretakers living on site and so on, where they get a house, they get the use of a house, but the benefit is not actually taxed. So I wonder if your point applies.
Well,
the answer to your question is that your point applies irrespective of the incidence of the benefits code.
Well, indeed, what I'm saying is you would tax the benefit according to the rules. So you'd start with section 62 because it takes priority. Then you'd look at the benefits code. You might have part 7A as well. That's what CIA and strategic branding. But you look at the benefit and you tax that according to all the normal tax codes, which includes the benefit.
I understand all of that. What I'm trying to do is to work out analytically, and if you like, for reasons of intellectual purity, what is really going on. And it is a payment of earnings at all.
We say...
Sorry, can I just finish the question? Do you mind? So forget about the benefits code, right? Suppose there had never been a benefits code. What I'm trying to understand is what is the nature of the transaction? Now, so let's say you have your £1 million house for the executive to live in. Now, many people in society might be forgiven for thinking, well, that's jolly useful. And it's certainly got a financial value. And why shouldn't they, if effectively, as part of their remuneration package, they're getting that, rent-free accommodation, why shouldn't they be taxed on that as part of the earnings, because it is part of the remuneration for the work they're doing?
And the answer to that is Tennant and Smith, which
Right.
is a case about a bank manager living in a house, which is it can be taxed as earnings in specific circumstances, but not, for example, Tennant and Smith, where the person had to live there and they couldn't sublet it and make any money from it.
Well, in that scenario, the benefit is not the capital value of the house.
not.
Which
Well, there's nothing.
never comes to own. It's the value of rent-free living for
Well,
X years.
well, indeed, it's different, but it's not the full capital value,
Yeah.
it's the annual value. And let me take, I'm going to jump ahead, the submission I'm going to, Apollo Fuels, for example.
Yeah.
So, Apollo Fuels, the discussion, so the employer bought second-hand cars. Doesn't say what the values are, say it's £20,000. Employer leases them at full market value to the employees. Questions for the Court of Appeal in the course of its discussion. Does that involve a charge under the benefits charge? And also considered is their earnings? Answer no. So you apply the normal rules for the benefit in question. You can apply both, and you say you might apply Part 7 as well. That's what you do in CIA and strategic branding. What I'm going to say is, okay, tweak the facts of Apollo Fuels, and we'll look obviously at how David Richards considered that. What if Apollo Fuels had said, actually, we're going to do exactly the same thing, but we'd like the cars to be provided. We're actually going to buy the cars, but we're going to get a third party to buy them. So we transfer £20,000 to a subsidiary or a trust. The trust then buys the car for £20,000, and then it leases them at full market value. All we've done is insert the payment. We've gone from zero tax, Court of Appeal says, to a charge on the full cost of the car. That cannot be right. That is counterintuitive, and David Richards, Lord Justice David Richards, said that even the charge on the annual value was counterintuitive. Charge on the full capital value is obviously counterintuitive, because when you look at benefits, we do have all these principles. I'm also going to take you to Wilkins and Rogerson. Wilkins and Rogerson, case of Appellant. Payment to a third party, a tailor. £15 to the tailor. Tailor will make the employee a suit. What is chargeable? Is it the £15, or or do you look at the suit and apply the normal rules to the suit? And the answer there was, you look at the suit. How do you tax a suit? You would tax it at second-hand value. So you just apply the normal rules to the benefit, and that was an emolument. That's before you get the benefits code. So all I'm saying is, you look at the benefit, you apply all the usual tax rules to the benefit. There is no justification for taxing the payment just because it's been made to a third party to provide a specific benefit and nothing more. Different considerations for a case like Rangers or Ochre, where you've got subtrusts, for example, and the payment's always going to inure for the benefit. And of course, the findings in that case that those are payments of bonuses. Completely different considerations. And that's the difference. We say, if a payment is made to a third party, which is not the reward for services, but is for the purpose of providing a specific benefit and nothing more, then the correct tax treatment is to tax the benefit, applying the relevant rules, earnings, benefits code, Part 7A. And all the case law supports that.
And if you haven't got a relevant provision,
Like in Apollo Fuels.
at the relevant time, the legislation doesn't in fact tax the benefit, qua benefit, then your submission would be, well, then it's a matter for Parliament to change the law, which no doubt it would do for the future.
Or in our case, in principle, the benefits code does apply to this loan, but there's a specific exemption, and the revenue accept we fall within that exemption. Why is that a surprising result when Parliament has provided a specific code of specific exemptions for taxing this type of benefit, and the revenue don't dispute we fall within it? Surely it would be inconsistent with that code and cut right across it to start taxing payments to provide that benefit. Just apply the normal rules to the benefit provided. Not necessarily, sorry, maybe it's about a very long answer to my Lord's answer.
No, it's very helpful.
Not necessarily only the benefits code, because we'll look at cases which predate the benefits code.
Yes.
Tennant and Smith, Wilkins and Rogerson, where actually you get to a similar place by applying normal principles.
I'm just wondering how crucial it is to your analysis that there is no intention for the payments of a trust fee remuneration. Even if there was, you might say that it can't be intended to be a benefit greater than that that's going to be conferred by the loan. So don't you end up in exactly the same?
Well, then I would run into ranges though. That is what. So that's what. On very different facts, the Supreme Court said was not the correct analysis. That all the, and that's what the Upper Tribunal actually found, because the only argument for the Upper Tribunal in the first tier was, all they get is loans. Revenue are trying to tax the loans. Loans aren't earnings, therefore there's no tax charge. Revenue shift the argument, say no, the payment in is remuneration. It doesn't matter what happens after that. So, no, I would. Although you might think that's an answer, in appropriate circumstances where the payment is a bonus or reward for services remunerated, it's actually the remuneration based on facts and the primary factual findings in a case like Rangers or OK, then that is taxable as earnings, because that is don't pay me, payment aren't agafa.
Yeah.
But if that is not the earnings, that's not the reward for services, the only reward for services is the benefit, then you get into that, then you get into the situation, well, that's the right answer. That's Apollo Fuels, that's Wilkins and Wilderson. We say that's how you answer this case.
It's very helpful. We will try not to interrupt you too much, because I know you have got a lot to go through.
So that's the first, and in a sense the most important question, which is whether the revenues principle, which Mr. Ghosh repeated multiple times, purpose of the payment is to make the loan is a reward for services, therefore the payment is a reward for services. We say that's not folly. No case law to support that. None was cited before you. There is a secondary question, but given when you step back from this case, and that's about the taxation of the loan, you might say, actually, given if we step back, maybe that's the more important question looking at this arrangement, which is how you tax real loans with real expectations that the loan will be repaid, which is our facts. HMRC's position is that genuine loans of the type in this case can be earnings. That is a radical departure from the case law, including, of course, Rangers' Upper Tribunal, where the finding of the loan was that it would never be repaid until death. That was the finding in Upper Tribunal. And the revenue did not challenge the Upper Tribunal's decision. Lord Doherty, sitting at that time in the Upper Tribunal, his judgment remains correct on the issue he decided. Because as the revenue accept, what they did is they changed arguments. What was surprising yesterday is that in all the revenue submissions on why loans are earnings, they didn't address Rangers' Upper Tribunal. The case they lost at the highest level has been decided, and didn't challenge. As the court will be aware, mentioned yesterday, a daily commonplace transaction is where a director takes a loan from their company, recognised in a director's loan account that is available to them only because they are a director. That is a perk of their office. And that loan facility, and that's because of their employment. That happens every day. And the terms of repayment are often flexible. For example, if you have an owner-managed company, the sole director essentially has complete control of whether and when they repay their director's loan. And no doubt this court will have in mind how HMRC's arguments apply in that very commonplace transaction. Because the effect of their argument is that a number of those loans are actually earnings. Query what happens when it's repaid. So you take a loan of £100,000. You look at the facts at the time of the loan being taken. It's flexible. Director may repay it next month if they can. They might repay it next year. They might set it off against dividends. Never actually repay it. Of course, that is a form of repayment. Revenue say that can be earnings. That's going to be an exciting proposition for every company, every owner-managed business in this country to apply. And there's no case law to support that submission. The only case they've got is the obiter comments in OCO, even though everyone accepts that OK was actually, the reasoning is wrong, it should have found, of course, the redirection argument was right in that case, because those were bonuses paid to a third party. It was decided before the Supreme Court, though. Even then, the actual decision of the first tier was, well, it's the payment to the subtrust. And then obiter, or maybe, in these particular circumstances where the finding was that even if the trustee demanded payment and it was not made, the trustee would not enforce. Query whether that's really a loan at all. The first tier clearly was, but extreme case. I'm not here to tell you that maybe that can't be earnings. Save that for a case where it matters. So that's a summary of what the company submits the answer is to this appeal. Where a payment is made to a third party, which is not itself remuneration, but is paid for the purpose of a third party providing a specific benefit and nothing more, tax the benefit. Which in this case means the payment isn't taxable. What are the tax rules that apply to the loan? Loans aren't earnings. If this had been done a couple of months later, it would have been. It would have been treated as earning under Part 7A. If they hadn't bought shares, you would have had the benefits code. But the point is, you applied the normal tax rules to the benefits.
And Part 7A was made retrospective to 2011.
2010, December 2010.
Was it 2010? Sorry.
Yes, that was incorrect.
But it still doesn't. But it still doesn't help.
Actually, I think it retrospectively came a couple of days after this transaction.
I see.
If this is November, it comes in December. So Part 7 has no application. And that's quite important. When we come on to strategic branding and CIA, we say, well, the revenues say, we made our submission and the tribunal didn't understand it. I say, no, the tribunal did understand the submission. It's very similar to the one being made in this case. It just didn't accept it. It accepted the approach I'm saying, which is look at the tax treatment of the loan. And it said loans aren't earnings in each of those cases, but Part 7A applies to the loan.
And just remind me, if this transaction was done under Part 7A, well, the loan
the loan's taxable. Yes, it would be. We can, if we have time, go through it. But yes, it would be a 554C.
Strictly the loans rather than the payment.
Yes. That is not to say, though, that just because you have a specific code coming in that taxes something else, that you can never have an earnings charge. Look at Heaton and Bell, for example. Not just make sure. I've already been set up sort of various submissions I've never made, like saying that you need a legal entitlement. It's definitely not the submission I've ever made. So I just want to make sure we don't go too far. So structure. Structure of my submissions is, perhaps has already been, 4 main sections. First, I will address you on the decision of the tribunal, but specifically its factual findings. And in the course of that, I think it actually makes sense to address the revenues ground 4 at that stage, which is the mischaracterisation of the factual findings. Second section, I will address whether the payment to the trust was earnings, which is the redirected earnings argument, which will involve looking at some of the older cases on emoluments and then a detailed look at the facts and decision. Facts of the first tier and range found by the first tier and the Supreme Court in ranges. And in the course of that, I'm going to be addressing the revenues ground 2. To foreshadow, as you've noted from my skeleton, the company's position is that the revenues specific argument that the upper tribunal allegedly found that there was some form of legal entitlement required, that's simply wrong. That's not what the upper tribunal was saying at all. When you read paragraph 127, it disavows that point. Third section of my submissions, I will address whether the loan was earnings. I hope to have time to take you to some of the case law on loans, including, of course, Rangers, Lord Doherty's judgment in the Upper Tribunal, which remains undisturbed. And I'll be addressing the revenues ground 3, which of course is the argument on loans. So as I foreshadowed, we say this is another red herring because no matter where the revenue put their case, they simply do not have the factual findings. And then the fourth section, in light of those points, I will address the decision below, so the decisions below, first to show you that the analysis of the first tier tribunal contained an error of law, albeit I'm not entirely clear whether or not that's actually in dispute. I'm going to come on to that as part of my introduction in a second, and that addresses the revenues ground 1. And then I'll take you through the upper tribunal decision and submit it contains no errors of law, or, if I need to, that any error of law was immaterial. That's the plan. If I'm running short on time, I may invert 3 and 4 because I don't want to be cut short on that important final section.
Yes.
Whereas the section on loans, I think, can be taken a bit more flexibly.
That's very helpful. And can I just mention that according to the agreed timetable, you're going to finish by 3:30.
That's the plan. I'm sorry about that. Well, I will. I'm going to finish at
You will.
3:30. Yes, I will finish at 3:30. Before I launch into that structure, I wanted to make a few preliminary comments on the nature of this appeal and the appeal below. This is a second appeal under section 13 of the TCEA. The first tier decided the case, but we say, and the Upper Tribunal accepted, it contains an error of law because, the most obvious point is, the tribunal decided, included in its decision, the proposition that in the vast majority of cases, a loan could constitute earnings if it was a reward for the employee. That proposition was not defended by HMRC before the Upper Tribunal, you'll have seen. It is not defended before you today. Mr. Waldegrave said yesterday, HMRC do not seek to defend paragraph 37. Mr. Ghosh put it differently. He said that at paragraphs 33 to, I think it's 39, the tribunal was asking itself a question it should not have been asking. Fine. If the tribunal asked itself a wrong question, that's an error of law. So the Revenue's actual argument, their key argument, is that the error of law was not material. They say it was an excursus, it was obiter. And they're entitled to make that submission, but they have to accept the very challenging hurdle that they need to overcome to meet, to overturn the Upper Tribunal's decision on that. Because under section 12, it's the provision that applies to the Upper Tribunal, once an error of law is identified anywhere in the decision, then the Upper Tribunal has a broad discretion whether or not to set aside the decision of the first tier. And we'll look in a moment, of course, at the usual approach, which is de gauche, materiality. So where that leaves us on section 12, which is the provision that applied for the Upper Tribunal, there is not, or at least there shouldn't be, any dispute that on the appeal to the Upper Tribunal under section 12, the Upper Tribunal was correct to identify an error of law in that passage, paragraph 37, paragraph 42, 44 later on. In which case, the Upper Tribunal had the power to set aside the first tier's decision. And no one disputes that it applied the correct principles, it applied de gauche. So, if the Upper Tribunal had the power to set aside the first tier decision and apply the correct approach, the only basis upon which the Upper Tribunal decision to set aside the first tier can be challenged in that respect is applying the ordinary threshold of appeals against exercises of discretion, i.e. the decision exceeds the generous ambit within which a reasonable disagreement is possible, sometimes phrased as no reasonable tribunal could have reached. And I've cited Viegas and Currell in my skeleton, but obviously it's the same test pretty much for any appeal against discretion. Even, and the test, of course, the Upper Tribunal is applying is a very low one. It's not whether it would have made a difference, it's whether the error law may have made a difference. They have to show that no reasonable Upper Tribunal, looking at this first tier, could have found that the error of law might have made a difference to the outcome. We say that's impossible in this case, given the terms of the first tier. You might disagree. You might say, well, maybe it didn't make a difference. Well, I think it didn't. The threshold for this court under section 14 is whether there's an error of law. Given it's an exercise of discretion, that's going to be immensely difficult, we say impossible in this case, given the terms of the first tier's decision. And the fact that the focus on the loans and whether it was earnings runs right into its conclusion at 56 and 57. And this is a good moment to take a look at de gauche, which is Authorities Bundle 950.
I don't think this is controversial, so it'll be very
It may not be controversial, but it is nevertheless critical to the submission I've just made, the point I've just made, and of course, when we come back at the end to look at the Upper Tribunal's decision to set aside. But yes, it's 93 to 95, the sideline passage. 94 and 95 address the question of when the Upper Tribunal can and should set aside a decision for first tier. The principles applied in the by our Upper Tribunal. There's no suggestion it made an error of law in terms of the test it applied. For 93, Lord Justice Henderson makes some observations on second appeals, which the company respectfully invites you to adopt in this case. And they are, first, the best approach is to look primarily at the merits of the Upper Tribunal's reasoning in its own terms, on its own terms, rather than evaluating its evaluation of the first tier's decision. Second, bear in mind that the Upper Tribunal is a specialist tribunal charged with determining tax appeals. Now, of course, the first tier is also a specialist, but the Upper Tribunal is the senior one.
Okay. I don't want to take up time unduly, but can I just flag one point? It may not matter, ultimately. But that first proposition doesn't appear to me to be what this court conventionally does in other contexts. So in employment appeals, we usually look at the judgment of the employment tribunal, not the EAT. And similarly in immigration appeals, we often look at whether the FTT got it right or wrong. We're not that interested often in what the Upper Tribunal said. But I don't want to distract you because there's a lot to cover.
So I have 93 in front of me, and that's also referenced for your reference, paragraph 51 of Pendragon.
I know that's what I know. This is the problem.
There are other tax cases. I think really it may depend on which way it goes. I mean, if you've got an Upper Tribunal upholding a first tier, then maybe the more obvious thing to do.
And it may depend on the nature of the issue, of course, as well. Because if it's an Edwards and Bairstow, then obviously you are looking at first tiers. But if you're looking at a situation where the Upper Tribunal, you find it was entitled to set aside the first tier, the first tier decision just drops away, other than its factual findings.
All I wanted to do was I didn't want you to go away thinking that this is just what the Court of Appeal does routinely, because it does depend on the context, and it's not actually what we do quite regularly in other contexts.
I won't be taking that away. I suppose the only point I'm making is that the courts have said at the highest level, including the Supreme Court, to show respect to the Upper Tribunal as a specialist tribunal.
We will certainly show them respect.
So now we are starting section 1 of my submissions after the introduction, which is the FTT's findings of facts. And we can take these reasonably quickly because you have already been taken through them, but I do want to emphasise certain points. So it's core bundle 1, 2, 3, wherever you may have the first tier's decision. We're only looking at the facts at this stage. I'm going to come back in part 4 to look at the analysis. And it's paragraph 15, which is headed facts, the facts, followed by 16, which is headed findings of facts. But there are certain points later on we need to take a look at. So primary findings, 1 to 4 is about the business. It had begun by Mr. Currell as a sole trader, then it became a partnership with his wife, Mrs. Currell, and then it was incorporated in 2002. Mr. and Mrs. Currell are both directors. 6, Mr. Currell was the driving force of the business, but Mrs. Currell was also important. Also reference that 7 of their sons, Luke and Jay, who increasingly becomes involved in the business, and later they become directors. So by the time we had this hearing, it was Mr. Luke Currell who was giving evidence as the then director of the company. At 8, there are various other important employees, in particular contract managers, who the tribunal finds are essential to the success of the business. The overall point being that while Mr. Currell is important, he's not the sole employee. He's not even the sole important or essential employee. 9, there was a culture of paying bonuses, but not to directors, instead to the contract managers. So this is not a case like Rangers, where there's a discretionary bonus scheme and a culture or arrangement to pay discretionary bonuses to a particular group to these particular employees. 10, there are 5 shareholders, none of whom have control. Mr. Currell did not have control of this company. So the revenue, various points yesterday submitted, he did have control. He doesn't have control. He's a minority shareholder. If you take him with his family, together they can do it, but it's not him. 11, Mr. Currell took a modest salary. That is entirely normal in owner-managed businesses, of course. You generally benefit from the company's trade through the payment of dividends. Dividends, of course, paid to all shareholders. And that leads to what we say are the critical findings at 12 and 13. Mr. Currell's evidence was, and we find as a fact, that if the company had not made the payment, the company would not have paid him an £800,000 bonus as remuneration for the work of the company. 13, we also find the payment did not replace remuneration, which Mr. Currell had sacrificed or reduced in anticipation of receiving it. We say those are crucially and potentially decisive findings of fact. And nowhere in this section on findings of fact, of course, does the tribunal say, notwithstanding all of that, we find that this particular payment was a reward remuneration. Those are the findings it makes. And it would have been, of course, totally out of character or against history for Mr. Currell to receive a reward of £800,000. His rewards were a modest salary plus sizable dividends. There's no history or suggestion that he ever would have received £800,000 as a reward for service, as remuneration. 15 is the creation of the trust on the 18th of November. The purpose of the trust, of course, is to reward the employees and the directors to incentivise them. The beneficiaries are all the employees, and that category is never narrowed, and there are no sub-funds for particular employees. Contrast Rangers, contrast Tough Glaze. No separate pools created, for example, like in Aberdeen Assets companies. For your reference, the trust deed is Supplemental Bundle 192, if you want to look at your own time of the definitions. Subparagraph 18. On the 22nd of November, the company approves the contribution. 19, on the same day, Mr. Currell applies for a loan in order to purchase shares and offers security for the loan. So this is not a loan to be used as he likes. He doesn't have free use of the money, of the actual loaned money. It's a loan which will have to be used for a specific purpose to buy shares.
It's not the term of the loan that it must be used for that
purpose.
If his wife had been willing to allow the shares to stand as security for the loan without being purchased by him, would it have been possible to?
Yes, that's true. Yes, but he did not have the shares at the time, the ones that he was going to secure. I am actually going to take you briefly to the loan agreement. In theory, he could have asked his wife to put up that. We don't have any finding, of course, about whether the trustee would have allowed that, or about whether Mrs. Currell would have allowed it. 20. On the 23rd of November, the trustee approves the loan and sends back a loan agreement, and it's signed. So if we leave for a moment and go to the supplemental bundle, just go to 104. We will check. Clause 6 is the requirement for the loan to be secured. Clause 6. Under clause...
It does need to be the borrower's shares, doesn't it?
Yes, okay, so... I think we might look at there's also the security. We'll come to that point. For your reference, there is also the charge at 111, which refers to those specific shares being, of course, the charged assets. But whilst we're on the loan agreement, the loan is for 5 years. Under 5.1, so before that, the choice is Mr. Currell's, whether he pays, in the same way as if you take a fixed term loan, you're entitled to hold on to the money until it expires. 5.1, after 5 years, the lender can serve a written demand, and at that point, once you have the written demand, then the borrower is required to repay. So if there's no written demand, there's no obligation to repay at that stage, but it's the right of the borrower. Back to the tribunal decision, we're at Core Bundle 129. We've just, 22 is the share charge deed, which I've just referred you to. 25, this paragraph is corrected. So the flow of funds is £800,020 to the EBT, then £800,000 to Mr. Currell's bank account, and then £800,000 transferred to Mrs. Currell, which goes into the company. Next section is headed Rationale for EBT and Loan. You could read this as a recitation of the evidence, but actually it doesn't really matter because it's accepted. We'll see when we get onto the findings of facts. It is under heading Facts. It's paragraph 29. So before the first term, Mr. Currell exhibited his bank statements showing that in 2015 he had the funds ready to pay the loan if called upon to do so. Paragraph 31 is the evidence about why the loan wasn't called in, and we'll see that is accepted. 34, the tribunal found the trustee was reactive. Now, the revenue places a huge amount of weight on that word reactive. It says the trustee was effectively reactive as regards applications to pay bonuses to company employees. In other words, they did not make any positive suggestions as to what amounts the bonuses should be. It was up to the company to make proposals, which would then consider them in accordance with its discretion under the trustee. Prior to 2019, no proposals were made, nor is there any evidence the employees approached them. So this paragraph is talking specifically about bonuses and the payment of bonuses. And it says, since it's already been noted in the decision, the trustee doesn't know anything about the company's business. The trustees wouldn't know who to reward. So they're going to take recommendations and they're going to consider them in accordance with their duties. This paragraph says nothing about the loan. It's talking about bonuses. It certainly doesn't say the trustees were controlled by the company or controlled by Mr. Currell, or that he could decide whether or not the loan was repaid. It's not even talking about the loan, it's talking about future bonuses. The HMRC try and found essentially their entire case on the loan on that one word reactive. It simply cannot bear that weight in a paragraph that's not talking about the loan. 35 to 36. In 2019, £50,000 of the loan was repaid and it was used to pay bonuses to other employees on which PAYE and NICs were paid. Paragraph 16 is then headed Findings of Fact. 2. By the time the arrangements were implemented, in November 2010, it had been agreed that funds contributed to the EBT would be lent to MC and would be used to purchase the shares. And that's picked up again later about the purpose of the payment. 3. The payment from Mrs. Currell to the company was treated as a loan from Mrs. Currell to the company, which could be repaid to her whenever she wanted. So that's the primary finding. The person who ends up with the cash is actually Mrs. Currell, not Mr. Currell. But obviously they are married. You would anticipate they would use their assets to benefit one another. They are separate individuals, though. Then the company notes the issue with Companies House, but it finds at 4 that the shares were the same ones which had been purchased from Mrs. Currell, and at 6, prior to making the loan and entering the share chart, the trustee had valued those shares. So the trustee had valued their security to ensure it was sufficient. And that's a point of distinction. There's no other case where the security for the loan in question. In fact, in Rangers, they changed trustee because one of the trustees started saying, well, I'm not sure about these unsecured loans, so they changed trustee, which they could because they were protectors. This is a secured loan. 8, the reason why the trustee made no demand for payment in November 2015 was because of a concern about double taxation. So the tribunal accepted the evidence at 15 sub 31. It doesn't say a reason or one of the reasons, it says the reason, i.e. the only reason. And nowhere in this decision does it suggest any other reason for why the loan was not repaid in 2015, was not called in 2015. 7, 9 and 10, until 2019, the trustees can't pay any bonuses because it has no money. It only has the loan, which we've just seen hasn't called in because of the concern about double taxation. The reference in 7 to Mr. Currell choosing to repay, of course, is a reference to the pre-2015 period. They had no right to demand prior to November. In reality, they had no power to pay bonuses prior to unless Mr. Currell voluntarily chose to repay. So before the loan is callable, it's Mr. Currell's choice. There is no finding that after 2015 it was Mr. Currell's choice. That's solely looking at pre-2015. Make sure we don't get lost in that paragraph. Those are the primary findings of fact, and then there are certain other findings made later on in the decision. If we turn to paragraph 141. Actually, sorry, the page before 140. So HMRC were making the same submission as they made in Rangers, i.e. the payment to the trust was a reward for services. I said no. I gave 3 reasons why the payment had been made, and the tribunal accepted my primary submission. Paragraph, which is set out at 29, which was the purpose was to make the loan. 30, in our view, having viewed the facts realistically, the substantial reason for the company making the payment was to enable the trustee to fulfil a commitment it made to make the loan. If the if the tribunal had accepted HMRC's submission, that would have been the end of the analysis. The decision would have stopped at paragraph 31. Payment to trust is remuneration, therefore Rangers Supreme Court applies. We would not be here. It did not accept HMRC's submission on the facts. Did not make the finding they wanted. And the tribunal repeats that point about the purpose at 31.8 and then at 32. It did not accept the other reasons, doesn't matter. The point is it rejected HMRC's submission.
31.8 and 32.
Yes, 31.8 and 32 set out same finding. The purpose of the loan is the purpose of the payment is to make the loan. So then we get the more convoluted analysis, which we're going to come back to later. That's where the error of law is. That's 33 to 37. But if we, just in terms of our making findings, paragraph 145, the conclusion at 37 is that the vast majority of loans can be earnings if they are rewards for services. So the FDT asked itself, was the loan a reward for services? And that's what paragraph 38 is asking itself. And at 42, just to note 42, there is no evidence the trustee exercised its discretion to make the loan anything other than perfectly properly. So they're acting in accordance with their fiduciary duties. We say that is inconsistent with the revenue's submission that Mr. Currell had practical control over them. Certainly there's no finding of control. Paragraph 43. The loan was a real loan with a genuine obligation to repay, which was accepted by Mr. Currell. No submission of sham. The tribunal found the loan was genuine, and there was and there's no suggestion there was any common intention that it would never be repaid or anything like that. Nor any finding that depended on Mr. Currell, or that he had practical control, or anything like that. And the tribunal has already observed he actually had the funds to repay it ready in 2015. Paragraph 44, you then have the legal point we're going to come back to because that's going to be very important in the error of law. So then it asks itself, well, why was the loan made? That's paragraph 53. To our mind, the only reason was because of the work Mr. Currell had done over the years. So the loan was a reward for services. And that is not a surprising finding. Because as the tribunal notes at 54, the purpose of an EBT is to reward employees by conferring benefits. And the benefit the trustee chose to confer was a loan. So it's quite a long section, but I don't actually remember at that point being contested. It's an employee benefit trust. Contest was about the payment in. It is important to note paragraph 54, 10 and 11. Mr. Elliott submits there's no evidence the £800,000 had not been paid by way of loan, it would have been paid to him by way of salary or other remuneration. That wording is critical. Or other remuneration by the company. We accept this. Entirely consistent with what's in the primary factor findings, the payment in was not remuneration. 11, but it's precisely because he'd been under-awarded, the trustee wanted to grant him a loan. So that's a restatement of the primary factual findings, that the payment to the trust is not remuneration. What is Mr. Currell getting? He's getting a loan. And it is the loan which will make up for the under-awarding, not the payment in. Paragraph 55, second sentence. We are satisfied is more likely than not, based on the primary facts, the reason why the trustee made the loan was because the services he had provided and the loan was a reward for those services. Just to complete the facts, the loan, of course, to Mr. Currell was not the end of the transactions. We've seen, he used it to buy shares. Whether he was obliged to do so or not, we can debate. He bought the shares from Mrs. Currell, who loaned the money back to the company. So if we go back to 146, paragraphs 50 and 51, the end position for Mrs. Currell, she used to have shares, she sold them for cash, which she's loaned to the company and she can draw down. So that's why the FTT notes at 50 that the funds are placed in the unfettered control of Mrs. Currell, albeit of course she can use them to benefit her husband if she so wishes. And she could draw down for the mutual benefit of herself and Mr. Currell. Those are the factual findings, other than the small revision in relation to the money movements. There's no challenge. The Revenue could have filed a respondent's notice in the Upper Tribunal. They could have made an Edwards and Bairstow challenge. If they didn't like the primary findings, or if they wanted the Upper Tribunal to draw further inferences of fact to support the submissions they make before you. They could also have made an Edwards and Bairstow challenge before you, inviting you to draw further inferences of facts, because of course inferences of fact are still findings, and therefore an appellate court needs to apply the Edwards and Bairstow approach. It needs to be a proper Edwards and Bairstow challenge. I'm sure Lord Justice Singh will remember the discussion in the Upper Tribunal in Marlborough, potentially if you read that, about the importance of making proper Edwards and Bairstow challenges. I looked last night at Lady Justice Falk's decision in A Taxpayer, referring to Phage, for example, about inferences having to be the subject of Edwards and Bairstow, the statutory residence test. The key points on the facts being, in relation to the payment to the trust, first, the purpose of the payment to the trust was enabled to the trust to make the loan. Second, the payment to the trust was not a replacement for salary or any other form of remuneration. And had the payment to the trust not been made, the same payment would not have been made to Mr. Currell as remuneration. In other words, that payment did not constitute his remuneration or reward for services. So, if the FTT had come to the opposite conclusion, it would have been a very short decision. On the loan, the tribunal focuses upon, because the loan was considered to be a reward for services, and the loan was a genuine loan with a genuine obligation to repay, which both parties understood. So the critical difference between this case and cases like Rangers or Tough Glaze is that the payment to the EBT is not remuneration. It's not a reward for services, and that's what puts it in a different category. Before moving on, just to make sure this doesn't get lost, important point is to compare the position at the start and end of the transactions. The sort of balance sheet position for Mr. Currell. We'll consider him alone, and then we'll consider him in conjunction with Mrs. Currell. So considered alone, Mr. Currell started with sort of nothing relevant. He's borrowed £800,000. He's used that money to buy £800,000 worth of shares. So his net position is unchanged. He has £800,000 of shares, but subject to a new liability to pay £800,000 under a genuinely repayable loan. For the sake of argument, consider him with Mrs. Currell. Together they started with the shares owned by Mrs. Currell. They've transferred them between them, no change there. They've borrowed £800,000 from the trust. Mrs. Currell has the use of those funds. She's put them in the company, but she has the use of it. So their net position is they've borrowed £800,000 and they've got cash, i.e. a loan. Because Mr. Currell has the obligation to repay it. That's what they get as a result of these transactions. £800,000. And that's important to keep in mind. What is the net effect of these transactions? Is that Mr. Currell got a loan relating to his employment. It is therefore unsurprising if the conclusion you reach is the proper tax treatment of these transactions is the proper tax treatment of the loan. I now have to address, we're still in part one, the revenues ground 4, and I'll try and take it short. So we've looked at the unchallenged tribunal findings. Obviously, you have to read the Upper Tribunal on its own terms, but I'm sure this court will have noted that the Upper Tribunal permission decision is actually very detailed and includes quite a robust dealing with all the grounds that were put to it. So for your reference, that's Core Bundle 105. You may find it helpful, but we do, of course, have to look at the Upper Tribunal on its own basis. There are 3 challenges set out by the Revenue at paragraph 62 of their skeleton. The first is the challenge to the reason why the trustee made no remand for repayment was the concern about double taxation. We've looked at that paragraph 16, it's headed Findings of Facts. That is practically word for what is stated at subparagraph 8. If you really want to be pedantic, the Upper Tribunal, it stated that it did not include the word why. It doesn't change the meaning of the sentence at all. So it's literally quoted the Upper Tribunal finding of fact. That is where the tribunal expressly recorded its findings of fact. It stated in clear terms there's no challenge to that. Moreover, the Revenue seemed to agree that a reason for non-payment was the double tax concern. They're not challenging that, but they can't point to an alternate to any other reason. Second alleged error is about the money not being placed unreservedly at Mr. Currell's disposal. What I'll say on that, because we're going to come back to it on the loan, is the tribunal clearly understood the position. For your reference, it's paragraph 101 of the Upper Tribunal's decision, where it sets out the sort of net balance position I've just described to you. Mr. Currell had a loan, he used the money to buy shares. Mrs. Currell had cash. Of course she did, she just sold her shares. So the net position is Mr. and Mrs. Currell have a loan of £800,000, which gives them cash until they repay the loan. That's it. Whether a loan means the money is unreservedly at the disposal of the borrower, and whether that is the relevant question, we'll come to on part 3 of my submissions. So that's not actually the right question, but even so, if a tribunal was simply saying, yes, you've got cash, but you've got to repay it, that's correct. Third challenge is said to be that the tribunal actually found the payment was made because of Mr. Currell's work as a director. That's what they say their challenge is, but of course nowhere is that recorded. And as I've said, it's obvious from the context of the tribunal's decision. Why does the tribunal spend so much time focusing on the loan if it actually had decided, or it should have decided, that the payment to the trust was remuneration, was a reward for services? If it had found that, that would have been the end of its analysis. Those are my submissions on the facts and addressing ground 4. We're now on to section 2, whether the payment to the trust is taxable as earnings. You've already looked at the legislation, section 62. It may be helpful just to pull it up again. It's Authorities Bundle 43 if you want to have it in front of you. Section 62 is the definition. There are 3 categories under subsection 2. Salary, wages or fee, and then there's gratuity or profits, which are a different category, and then there's anything that constitutes an emolument. And section 62 is actually a codification of certain principles. that have been established in one of the well-established cases in relation to what was Schedule E, such as Tennant and Smith, Wilkins and Rogerson were about to look at, which taxed emoluments, which is still the same question we're asking, so those cases are still relevant. Earnings or emoluments, that's a critical concept for there to be a tax charge, but that's not enough. There also has to be, as we saw, Section 15, which takes you to Section 18, there also has to be a payment. And it's also stated, for example, Regulation 21 of PAYE regs. And that's why you have two requirements. Emolument has to be paid. And the main reason I'm making that point is we just need to keep in mind those two requirements when we look at some of the case law. Because the case law relied upon by HMRC, in particular Garforth and Aberdeen assets, are not about whether or not the payment, the amounts were emoluments. That was common ground. Those cases were about whether there was a payment. So it's highly unlikely they're going to tell us anything that helps us in this case. And of course they didn't concern loans, we'll come on to them later. That's why I just remind us of the two conditions, and we have to think each time. And Lord Hodge is actually also addressing the payment condition when he talks about those cases, we'll see. So turning now to some of the fundamental principles on emoluments or earnings. I'll show you some cases, but just two principles. First principle, the charged earnings is a charge on the benefit which the taxpayer receives, not on what the employee saves, nor on what the employer pays. And when I say receives, I mean in the Ranger's sense. The employee doesn't actually have to receive literally the money directly. But the focus is not on what the employer pays or on what the employee saves. Second, where the payment is not an outright payment of money, there will only be earnings or an emolument if and to the extent that the employee can convert the benefit to money. And that is effectively what's codified in 62(2)(b). So Authorities 327 is Tennant and Smith. So Tennant and Smith is a case about a bank manager. The bank manager was allowed and in fact obliged to occupy the bank house as part of their employment. He was not permitted to sublet the property. The issue was whether that gave rise to an emolument under what was then Schedule E. The House of Lords said the occupation of the bank house was not assessable under Schedule E as an emolument. Page 341. Just going to ask you please to read the conclusion of Lord McNaughton. It's the sidelined passage. Confirmation that the charge is not on what saves his pocket, but what goes into his pocket. And similarly, 334, Lord Halsbury. It's the final paragraph of Lord Halsbury's judgment. For this reason, I'm of the opinion, the words of Lord Young, that the thing sought to be taxed is not income unless it can be turned into money. This is all pre what we would call now the Benefits Code. Those are the fundamental principles. Would have been very different if he'd been allowed to sublet it potentially. Then you could have had earnings, but not on the capital value of the house or anything like that. No one was suggesting that. Wilkins and Rogerson now. That's 530. Might I ask you please to read the head note. So everyone's got to the end. In Wilkins and Rogerson, the employer wanted to provide a benefit to the employee, but the employer did not intend the cost, the payment they were about to make, to be the reward, i.e. the cash. Nor was it intended that the cash represented their salary or remuneration. Instead, the arrangement was they would pay £15 or up to £15 to a third party, a tailor. And the tailor would provide a specific benefit to the employee in the form of a suit. So in the case of Mr. Rogerson, cash of £14, 15 shillings, I'm going to round that up to £15, please, is paid for the purpose of providing a specific benefit to the employee. Revenue argue, if we go to 535, it's the top paragraph that starts, that I say, the claim of the Crown has been that the figure of £14, 15 shillings, i.e. the cost to the employer, is to be treated as part of the taxable income of the employer for the tax year in question. It is said it falls within the terms of paragraph 1 of the 9th schedule, and then it cites the wording of Schedule E. Then we pick up at the end, it is the Crown's case that the £14, 15 shilling must be treated as a perquisite or profit from the employment of the year of assessment. On behalf of the taxpayer, it was said if any purpose or profit was limited in this case to the value expressed in money of the thing which he got, namely the clothing. So the taxpayer resisted, arguing the arrangement was for the taxpayer to receive a specific benefit, a suit, and nothing more. And the value of the suit was £5 in second-hand resale value. And the Court of Appeal agreed with the taxpayer. And the respondent submits this case is important in the context of our case because the facts are, employer has made a payment of a sum of money to a third party for the purpose of providing a specific benefit. In circumstances where the payment of cash to the third party is not a salary or bonus or reward for services, rather the reward is the thing that the third party is going to provide using that cash. That's the benefit that arises from the arrangement, the suit, and nothing else. On those facts, is tax charged on the payment made by the employer to the third party, out of which the benefit will be provided? Or is it charged on the actual benefit received by the employee from the third party? Answer, under an arrangement of that type, when the employer's payment is not remuneration, and it is only made for the purpose of providing a specific benefit and nothing else, you apply the normal tax rules to the benefit. And this is pre-benefits charge. So the question was, well, what account can you turn from the suit? You can sell it second hand, it's £5. And that is set out, it's 536. May I ask the court please to read the sidelined passages in the judgment of, I believe it's Lord Evershed, and the short judgments of Lord Justice Harman, which is also sidelined.
Thank you. Mr. Early, can I just mention a very small point? Please don't take time over it now, but if somebody could send us an email in due course. I noticed this law report is volume 2 of the weekly law reports, which suggests that it would have been reported in the full law reports, probably Chancery. So if we can have the law reports reference.
I will make sure that is actioned. It may even be done during the course of today.
Right.
To your, we will send it to one of the court clerks, if we may, address which we have.
Thank you.
So, Wilkins and Rogerson is not a case like Rangers, Aberdeen Assets or Tufglaze, where the employer wanted to pay a bonus of £15, i.e. that's the reward for services in the form of cash, but which it's paid to a third party. Rogerson is a case where the employer was willing to spend £15 by paying it to a third party as part of an arrangement where the employee would get a specific benefit from the third party and nothing else. I submit the outcome would have been exactly the same, regardless of who the third party was. If the employer had paid £15 to a trust, and then the trust goes out and buys the suit and gives it to Mr. Rogerson, and he can keep it forever, the tax treatment must be the same. I.e., he's taxable on the benefit, he gets the second-hand value of the suit. So, we say Wilkins and Rogerson is directly analogous to this present case, where a payment is made to a trust, but the payment is not the remuneration, it's not the reward for services. Rather, the purpose of the payment is so that the third party can provide a specific reward, specific benefit, which in our case is a loan. Tax analysis of those facts is to apply the normal tax provisions to the benefit provided by the third party. We'll come back to address that principle sort of a common sense way at the end of this part. I'm now going to do a long diversion looking at ranges. There's the principle that in order for a payment to be taxable, it must be the remuneration of the employee, i.e. a reward for services, is confirmed by the Supreme Court in ranges. It's common ground in this case. And the scope and limitations of the Supreme Court's decision in ranges are well established. I think they are not in dispute in this case. Headline points are as follows. They're the same headline points put by the Upper Tribunal in our case. First, by the time the case reached the Supreme Court, the issue was whether the payment to the trust was a payment of earnings. The Revenue had initially argued and abandoned all their arguments about the loan being earnings. That doesn't mean that Lord Hodge thinks the loan is irrelevant. We'll return to that analysis, the Upper Tribunal, when we come to part 3. Second point. It was common ground in ranges that the payments to the trust were remuneration for services provided by the employees. I'll take you to some of the underlying facts and evidence on that, as well as it's all stated very clearly in the Supreme Court. The only outstanding question, therefore, was whether those payments of remuneration were precluded from being taxable as a payment of earnings because and only because they weren't paid directly to the employee. That's it. Third, the answer to that question is the general rule laid down by Lord Hodge, paragraphs 59 and 41. Employment tax is chargeable on remuneration, paid in money or money's worth, and that a charge arises regardless as to whether it is paid to the employee or the third party. So, had the FTT in our case accepted the Revenue's factual submission that this payment was remuneration, this would have been a very short case. But it didn't. So the Supreme Court decision range is important, is that it confirms that in order for a payment to a third party to be taxable, it has to be remuneration. It has to be a reward for services. That's common ground. If in our case, the payment to the trust is not remuneration, and obviously we'll look at how Lord Hodge got to that conclusion, then there can be no charge on that payment. And this is an orthodox interpretation of what ranges does and doesn't decide. Ultimately, it does not decide a huge amount. The Upper Tribunal in our case, referred, for example, to the Upper Tribunal in Marlborough, which endorsed the first tier's analysis in Marlborough, which is a very impressive judgment from Judge Morgan. The Revenue did not challenge any of those principles before the Upper Tribunal, and that includes a discussion of ranges, which is identical to what I've just said. Key point being, what ranges does not, at least the ratio does not tell us, is when is a payment remuneration. The ratio. Of course, later we have to look at the application, because Lord Hodge does give 3 reasons why payments. And we say, the Revenue say, ignore that. We say those are important, because of course none of those facts are present in our case. The facts I think you'll be familiar with now
So which page are we on now?
Well, I was about to take you briefly to Authority 770.
Thank you.
I think you've already seen this though.
Upper Tribunal.
So this is Upper Tribunal, and the facts cited by the Upper Tribunal are taken from 103 of the first tier tribunal. This is the summary. Big headlines. There's a principal trust. The principal trust established sub-trusts for each employee, 108 sub-trusts in total, of which the employee was the protector. The trust mechanism was explained to each employee on the basis they would get a tax-free sum greater than if they were paid a salary. And we see in particular Roman numerals 11 and 12. The footballers' terms of engagement were an employment contract and a side letter, and the side letter provided the employer would establish the sub-trust for them. For the non-footballers, they had no contractual right to a bonus, but there was a practice of paying discretionary annual bonuses based on performance. And I completely agree with the revenue submissions in this case that we have to focus on the employees who didn't have the contractual right, because we don't have a contractual right in this case. We have to focus on the facts relating to why the court considered that those payments were remuneration even though they were non-contractual. It's a bit difficult because the court does tend to start with the footballers and then says, oh, it's all the same for the employee, it's all the same for the non-footballers other than this point, so we have to be a bit careful. But we have to focus on those employees. Roman numeral 5 as well, just to note, the loan would be repayable out of their estate. And we'll go through, I'll show you some paragraphs. This is important, and we'll see further references.
Where are you reading from?
So I'm Roman numeral 5 in the quoted passage. See, 4 lines down, repayable out of his estate. Now, don't miss that, we will see the evidence. So the plan and the expectation of everyone was that these loans would just be renewed and renewed, and they would never be repaid by the employee during their lifetime. That's why there would be a debt on the estate, i.e. when you die. Tribunal evidence. I don't want to take too long on this, but perhaps just to show you some paragraphs which add a bit of context to that summary. So it's first tier tribunal decision. We're now at 607 of the bundle. If I may, I'll just indicate the paragraphs and sort of just summarise sort of the point being made. And I said, once again, I'm trying to focus largely on the evidence of the evidence relating to the non-footballers. So paragraphs 11 to 13 is the evidence of Mr. Red, who is a senior manager. Paragraph 12 in particular notes the payments to the trust for the benefits of the non-footballers are stated to be in lieu of the bonus they would otherwise receive under the discretionary bonus scheme. That's the final line of 12. Paragraph 13, we have the point that the loan could be extended and would remain outstanding at death. Next page, paragraph 20. How was the matter introduced to Mr. Yellow, who was another non-footballer, by saying, we're thinking of paying you a bonus. Next page, we're on 609 now, paragraphs 25 to 26. Mr. Green was another non-footballer. There is a non-anonymised version of this decision, but the reported version is this one, so this is the one we've got in the bundle. Paragraphs 25 to 26. Mr. Green was another footballer. He had previously received bonuses subject to PAYE, but in 2004 it was proposed he be paid the bonus via the trust. Paragraph 27. The evidence of Mr. Violet, a former manager. Final line of the page. He had used the loan and had not expected to have to make repayment during his lifetime. Paragraph 32, in line with letter H. Mr. Gray, I should have said, sorry, I am giving you the evidence for the loans as well, because this will save me time later when we get on to ground 3. H. Mr. Gray, who is a solicitor whose clients had included various personnel, referred to the loan having inheritance tax benefits because it would still be outstanding on death. And paragraph 34 over the page, the loan was described as a revolving facility. Page 612, paragraph 44. Mrs. Crimson, who was the new director of Trident, so as the director of Trident, the new trustee, why had Trident replaced Equity, the original trustee? Because the previous trustee had been hesitant about advancing unsecured loans, so they'd been swapped out. More compliant trustee. Page 615. Mr. Blue, who's another non-footballer employee, at the end of paragraph 53, we have another reference to the inheritance tax. And then paragraph 55, Mr. Blue explained that a decision was made annually by Mr. Black whether he and two other senior executives should receive a bonus. Mr. Blue had no contractual right to this. He would be given the opportunity to receive this provision by the Remuneration Trust, and he found that attractive. Confirms again in the next paragraph, non-contractual. And the tribunal accepted that. If there had been a contractual right, then that might have given rise to a charge. Page 617. Please read paragraph 65. So the evidence on the loans was they were initially for a 10-year period, but they were expected to be renewable for a continued term and therefore offered inheritance tax advantages because they were debt on the estate at death. And just for your reference, similarly on the next page, paragraph 71 to 72 say the same for Mr. Scarlett. And that all leads to page 624. So in between you have the evidence of the HMRC inspectors, but you get to page 624, and that's the paragraph we've already looked at, which was cited in the Upper Tribunal decision. With that context, we can now turn to the Supreme Court's decision, which is page 908. Paragraph 1. The appeal concerns a tax avoidance scheme by which employers paid remuneration to their employees through an employees' remuneration trust in the hope the scheme would avoid liability to tax and NICs. The appeal raises a fundamental question about the nature of the income tax charge. The question is whether an employee's remuneration is taxable as his or her emoluments or earnings when it is paid to a third party in circumstances in which the employee has no prior entitlement. So right at the outset, Lord Hodge identifies the payments in questions were remuneration. And the issue before the Supreme Court is whether remuneration which is paid to a third party is taxable as earnings. And that's not in dispute. Just to take us out of sequence for a moment, please go to 917. Paragraphs 32 and 33 summarise the decisions of the tribunals below, and then 34 is the taxpayer's challenge. RFC challenges this conclusion. Mr. Thornhill submits on its behalf that the Inner House erred in applying what it calls the redirection principle in the second case. In essence, he asserts that it is not sufficient that the payment of money arises from the performance of duties of employment. Payment of money so arising to third parties does not amount to the payment of earnings or emolument unless the employee already has a legal right to receive a payment. So the taxpayer is not contesting that these amounts were rewards for performance of duty. They just said it's not enough. We go back now, please, to 908. Paragraph 2 summarises the FTT and Upper Tribunal decision. Paragraph 3. The Advocate General for Scotland on behalf of HMRC appealed to the Inner House and advanced a legal argument that had not been presented to have at least been developed before. This is common ground. After the Upper Tribunal, the Revenue changed their argument. They changed counsel, they changed their argument. They abandoned the loan argument. This argument had not been pressed before the Upper Tribunal, and that's why I say when we go back later to look at the loan point, that Lord Doherty's analysis remains unchallenged and unoverturned, because the Revenue stopped arguing the loans are earnings and just shifted argument. His judgment and his reasoning remains correct in respect of the argument and the issue before him, which is whether the loans were earnings. Paragraphs 4 to 9, Lord Hodge sets out the legislation. Just note at paragraph 7, Lord Hodge has very much in mind the legislation relating for the requirement of a payment. Refers, for example, to the PAYE regulations. Then paragraphs 10 to 6, and then paragraph 8, sorry, he emphasises that point about the need to be a payment of emoluments. Paragraphs 10 to 16 is the correct approach to statutory interpretation. Then we get to paragraph 17 on 913. Lord Hodge states he's considered the judgment of the majority. He's also looked at some of the underlying documents. So you actually get a couple of points and references to documents that you won't find in the first tier decision in this judgment in the Supreme Court. Paragraph 21. In line with G, we see a description of the loans and the expectation that they would not be repaid at term but would be renewed and repayable out of the footballer's estate. Also, the powers of the protector to change the trustee and choose the beneficiaries. So the employee has direct powers to decide who is ultimately going to benefit from this money. Paragraph 22 is the description of the side letters. Paragraph 23, it is clear from the documents which before the tribunal are made available, as examples are arraigned that the sums paid to the principal trust and the subtrust represents remuneration for employment. And then there's references to an example, including an agent recording the footballer's remunerations. This is on the footballers at this stage. Paragraph 25, Lord Hodge refers to the practice of the employee completing the letter of wishes for their subtrust. Please could you read or remind yourselves of paragraph 26, the content, about the powers. Paragraph 27 records that players who left the club were able to unscramble the trust and receive an absolute right to the monies in the sub-funds. And Lord Hodge considered this was a consequence of their powers as the protector, cooperating with the trustee. Paragraph 29, first few lines, is the reference to the change of trustee in Trident, proving more compliant with the employer's wishes than equity had been, and we saw the evidence on that. Those paragraphs are all looking at the footballers, but then we get 31, the executives. The other companies in the Murray Group, which were respondents before the Court of Session, used the same trust mechanisms and the loans when paying discretionary annual bonuses to senior executives. So all the facts we've just seen in relation to the trust, the subtrust, the loans, apply equally to the executives. The majority recorded, paragraphs 103, 11 and 205, which we've looked at, that these bonuses differed from the footballers' bonuses, which were agreed on engagement, as the senior executives had no contractual right to the bonuses before they were awarded, but the bonuses were paid as a reward for the work which the employees had carried out in their capacity as employees. So the court recognises there were differences between the footballers and non-footballers, because the footballers' bonuses were agreed in advance, but that is not a material distinction, because the bonuses were a reward for services, and that's all we require. They were remuneration. They were not merely derived from, caused by, linked to employment. They were the reward. Paragraphs 32 to 34, a summary of the appeal we've already looked at. Paragraph 36 The central issue in this appeal is whether it is necessary the employee himself or herself should receive, or at least be entitled to receive, the remuneration for his or her work in order for that reward to amount to taxable emoluments. Paragraph 38, there's a reference to section 18, which is the requirement for a payment. It's actually set out by the court. I know it wasn't set out earlier, it's set out here. 41, having set out the legislation, Lord Hodge says, as a general rule, therefore, the charge of tax on employment income extends to money the employee is entitled to have paid as his or her remuneration, whether it is paid to the employee or a third party. What does Lord Hodge mean by entitlement? That could be a reference only to the footballers. Doesn't really matter, because no one in our case is arguing that when you read Lord Hodge at all, he's ever been saying that a payment is only earnings if there's a prior contractual entitlement. That's not the basis for the Upper Tribunal's decision either. It disavows that point. Then he goes through the exceptions, none of which, so it goes through various exceptions, and there's perquisites, and then the second exception at 46 is a benefit capable of being turned to money, and we've looked at some of those cases. Interestingly, at paragraph 46, whilst we're here, a second circumstance which falls outside the general rule is where the employer spends money to confer a benefit in kind which the recipient cannot convert into money. Okay, so what type of benefit is Lord Hodge thinking of? Such expenditure is not a perquisite or profit, gratuity or incidental benefit for the reasons discussed above, and only falls within the income tax regime because of the special statutory provisions, i.e. the Benefits Code, which cover, among other provisions, living accommodation, cars, or loans, or the payment of expenses. Part 7 ITBA also has provisions for shares. So Lord Hodge includes loans in this second category, refers to the specific legislation, and he states that such benefits, such as loans, are only chargeable because of the Benefits Code. That is something the revenue need to grapple with if they're going to found their ground 3. Third exception is paragraph 47, which is about contingencies. I'm going to come back later to make one point about Ford and McHugh. And then we're on 51. Lord Hodge is about to start the analysis of Garforth and Aberdeen assets. He does so at 51, though expressly acknowledging he's no longer addressing the question of whether something is an emolument, he's addressing the question of whether there's been a payment. Quite rightly, because that's what those cases are about. He says, as well as ascertaining whether remuneration amounts to emoluments, it's necessary under the provisions relating to POA to determine whether there's been a payment. And that's what he's addressing, just to make sure we don't get mixed up here. He recognises Garforth and Aberdeen assets, which I hope to have time to take you to, are expressly looking at the question of whether there's a payment. In fact, both those cases, the taxpayer accepted there was a tax charge. The question was only, is it collectible under PAYE? So those cases are not going to help us in identifying whether there's an emolument. If we had a debate about whether there's a payment, then we might be looking at those cases. Of course, those cases have become, in a sense, much less important. Now you've got the Rangers principle that a payment to a third party is also a payment. You could say Aberdeen, well, I mean, that's a bit different. If you had had a scheme in Aberdeen assets where the payments are made to a company where you can wind up with the money box companies, the correct answer might have been, well, it doesn't matter what powers you've got in relation to the company. You've got a payment to the company to a third party of your acquiescence. Paragraph 51, we also have the well-established warnings about judicial glosses. And that's directed at this point about unreservedly at control, which of course is a gloss. In particular in cases, of course neither of those cases we're looking at loans. Paragraph 58, so it goes through various cases. Paragraph 58, we get another statement. In summary, 1. Income tax on emoluments or earnings is due on money paid as a reward or remuneration for the exertions of the employee. That's it. That's the rule. If and only if the payment is a reward or remuneration. And then 2, focusing on the statutory wording. Neither that wording nor the provisions I've quoted suggest the employee has to receive it directly. And then 3, you've read the rest of that paragraph. We then have the application section. Now you might think, given everything that's gone before, that the answer is going to be answered in 2 lines here. Because Lord Hodge has said repeatedly, and in fact it's common ground, that these payments are remuneration. They're rewards for services. But Lord Hodge still does an analysis. He gives 3 reasons as to why he considers the payments in this case are remuneration. The first is the nature of the payment. And at paragraph 61, we see the reference to the side letters. But if we can jump out of sequence, paragraph 66, he makes the same point, i.e. the nature of the payments in relation to the executives. The fact that bonuses were voluntary on the part of the employer is irrelevant, so long as the sum of money is given in respect to the employee's work as an employee. And he makes a reference back to 31 in that paragraph. Of course, paragraph 31, he'd said, the bonuses were paid as a reward for the work which the employees had carried out in their capacity as employees. So reason 1 is the nature of the payment. But he doesn't stop there. If we now go back to the second half of paragraph 61, the second one is the loans and the expectation they would not be repayable during the life of the employee. Lord Hodge thinks that's relevant. And so already we've seen factor 1, is it remuneration or reward for services? In our case, the answer is no. No finding from the FTT on that. Second point is these loans that are never going to be repayable during life. Another factor not present in our case. Third factor, 62, is the subtrusts. Even when the loans were repaid, the money goes into a fund for the footballer's family, where they are the protector. They choose the trustee and they choose the beneficiaries. Keep in mind also the earlier reference to the fact it was possible to unscramble this arrangement. They could get the money as a result of their powers. So Lord Hodge thought it was necessary, or at least relevant, to list 3 factors as to why the payments in ranges were a reward for services, why they're remuneration. And none of them are reflected in our case. Because there's no subtrusts. For example, the funds sit in a trust, in the main trust in our case, and the funds in that trust can be used and have been used to benefit a number of different employees. And on the loans, there's no finding the loans would be extended till death. To the contrary, the finding of the FTT is there's a specific reason why the trustee doesn't call in the loan in 2015. It's because of the double tax fear. And the revenue quibble about the term double tax. The point is, you've had tax, according to the revenue, it's taxed on the way in, and it's taxed on the way out, and it's taxed if you then repay the loan and pay a different person using the same money. And of course, you don't have the findings. We've looked at the tribunal's findings about these payments being a reward for service. So none of the 3 factors relied on by Lord Hodge are present in our case. So now we come to address.
Given it was common ground that the payments were remuneration, is Lord Hodge getting at something else here?
My lady, I learn more about ranges every time I read it. You may have something in mind.
Well, only that if what he's addressing in 61 is the remuneration point. Why is he doing it? I haven't actually necessarily got an answer to my own
Well,
question.
the inference is he thinks it's important to explain why, in this case, it is appropriate to find that the payments are remuneration, i.e. reward for service. I mean, that's the only inference. Otherwise, why didn't he just
It
say
doesn't go to the payment limit at this stage, does it?
No, he's looking at why their remuneration. He's already decided the point of principle that it doesn't matter. He comes back, he's already cited the fact, he comes back in this stage saying, why are these payments remuneration? That's his opening. The payment of the money was a component of the remuneration of the footballers and other employees. He thinks it's important that he comes back and explains why on these specific facts you can have the revenue charging the full payment to the third party, even though you could say all they get at the end is a loan. But actually, part of the answer is, well, they don't actually. They get a loan for life, and it goes into a trust, a money box where they can use. That's one of his reasons why it's not. He thinks it's important. So that's I think it is relevant. Otherwise, why does 60 not say, given it's all common ground that this is remuneration, that's the end of the appeal? So that's ranges. I'm now moving to address, I'm still in part 2 of my submission, I'm addressing the revenues, ground 2. As I understand their position, the revenue accept they can only tax the payment to the trust if it was the remuneration of Mr. Carr, if it was a reward for services. And that follows from what we've seen in ranges. They accept when they go through the primary findings, there is no express finding of this nature. They ask you to remedy that by making the factual inference through sort of reverse engineering. They say the loan is the reward for services. The payment was to make the loan. Therefore, the payment, the full £800,000 is reward for services. I invite you to decline to follow that logic. For the following reasons. First, it was rejected by the first tier tribunal in terms of its primary findings of facts. The revenue argued the payment to the EBT was a straightforward Rangers payment of a bonus. It was a reward for services. The tribunal did not make that finding. It accepted my submission that the reason for the payment was to make the loan. Secondly, these are the decided cases. The most obvious one is Wilkins and Rogerson. Payment of £15 to a tailor to provide a suit to the employee. Is tax charged by reference to the full £15, i.e. the cost to the employer? No, it's charged on the benefit, the specific benefit provided by the third party. Because that is an arrangement where the payment is being made to the third party to provide the employee with a specific benefit and nothing more. The effect of the revenues argument is that they're trying to tax the cost to the employer, which of course is totally contrary to very well-established principles we looked at, like Tennant and Smith and Wilkins and Rogerson. I say there's also some support to be drawn from Ford and McHugh. That's it. It's not called Bible. 812, 17. 825 is Ford and McHugh, and the facts are at paragraphs 2 to 3 on 827. Basically, there's a trust being set up to provide benefits for employees, but the employee couldn't receive the benefits until a date that was to be agreed with the employer. So the arrangement is payments being made to a third party, a trustee, and then specific benefits to be payable in the future. Subject to, we'll have a look at the reasoning, there is a contingency in this case. I'm not going to sort of pretend this is the only reason. And this is a case about NICs, but of course Lord Hodge then refers to it in Rangers. Page 830. Lord Hodge says it is not earnings, and he gives 3 independent reasons. The first is the double tax. That's paragraph 60. The third is contingency. That's paragraph 80. The second is paragraph 17. Secondly, it is only by looking exclusively to what was paid and ignoring what the earner received that the revenues view can be sustained. But such an interpretation of section 6 denudes the words earnings of any meaning. So the phrase earnings are paid would amount to payments are made in respect of any one employment. Earnings in this context are remuneration derived from the employment. The use of the word earnings points the reader towards what the employee obtains from his employment. Looking to what the earner received avoids the counterintuitive results. Lord Hodge says, don't look at what the employer paid to the third party, look at the benefit the employee is going to be provided by the third party. The payment in is not remuneration. And when he comes to distinguish Ford and McHugh in Rangers 922, he mentions this. Paragraph 48. Recent judge, page 922, paragraph 48 we're on. I hope this pace is all right for the court, by the way. The recent judgment of this court in Ford and McHugh is consistent with the approach in Edwards and Roberts in holding the sums paid by an employer other than out of employee's salary, which were to provide contingent benefits to employee, did not fall within the charge to NICs on earnings. Otherwise, on HMRC's approach, the legislation in question, liability would have arisen twice. So there is no doubt, I'm not going to go over this, the primary problem, Lord Hodge said, was there's double tax. But that is not the only reason. He gives 3 reasons we've just seen. Mr. Thornhill founds on this case, in particular on paragraph 17, the judgment that what an employee received to support his submission that the payment of remuneration cannot be the payment of emolument unless the employee is entitled to receive it. But Ford and McHugh was not concerned with the payment of an employee's remuneration to a third party, or the provision of money to the employee without the interposition of the contingency. What the court said should be read in context, and it sets out what that context was. So Lord Hodge refers back to what he said in paragraph 17 about the payment in Ford and McHugh not being remuneration. It was a payment to a trust to provide specific benefits. He says that was his second independent reason, independent of the contingency, that was rule 3, independent of the double tax point, it was not remuneration. So I do draw some support there as well from Ford and McHugh. And for what they're worth, you also have the first tier decisions in CIA and strategic branding. Of course, I'll take quick. So it's page 1116. Now, Mr. Ghosh says the tribunals keep misunderstanding his submissions. I submit no, they just aren't accepting his submissions. And it's essentially the same submission as in this case. So this is CIA. I'll just take the early bits briefly. So paragraph 183, 184, there's a discussion of section 62. There are 2 issues in this case, earnings and then part 7a. Then you have the discussion of Ford and McHugh on the next page. And then the next page you have the discussion of Rangers. So that's the background, referring to all relevant cases. And that takes us to paragraph 197. It is clear from the authorities that the contributions made by the company to the trust are not prevented from being taxable as earnings by the fact they were not paid directly to the shareholders themselves. That was not disputed between the parties. The question is whether on the fact the amounts paid by the employer are earnings derived from employment, i.e. a reward for their work as employees. Yes, that's the correct question. Mr. Ghosh submitted that contributions were all such a reward, as nothing else explains why the money was received by the shareholders to spend on private assets. And that's back, if you go back through the archaeology of the case, they got the loans and they bought whatever they wanted. And they buy cars and jewellery and things like that. So Mr. Ghosh is running essentially the same argument as in this case. The employees get their hands on cash in the form of loans to spend on whatever they like. So that means the payment to the trust must be remuneration. Paragraph 199, no. As acknowledged by Mr. Goach, earnings includes a connotation of reward for services. In Ford and McHugh, the Supreme Court focused on what was received by the employee in the context of a contingent rather than vested interest. Here, all the amounts paid to the shareholders were paid to them under finance agreements, pursuant to which they have an obligation to repay those amounts to Mel. Whilst the shareholders control Mel, they have not repaid those sums, which were already due. HMRC have not argued the finance agreements do not have a legal effect in accordance with their terms. Accordingly, I find the shareholders do have an obligation to repay. I'm not satisfied that receiving such a loan is a reward or benefit, even though I found it has a connection with employment. I therefore agree with Mr. Venables that they're not earnings on general principles. So the tribunal is saying the payments are being made to the third party gives loans and nothing else, and accepts their real loans. In those circumstances, the focus has to be on the correct taxation of the loans, because that's the only benefit being provided by the third party. There's no earnings, but in this case, Part 7A applies to tax the loans. So you apply the normal tax rules to the benefit provided by the third party. Not earnings. This is a post-Part 7A case. You do have a tax charge, but only because of Part 7A. Strategic branding, same analysis, similar. That's at 1002. Paragraphs 205, 206, and 205. In the present case, I'm satisfied that payments of contributions to the trust by the company are intended to deliver payments to Mr. Wilson in the form of funds. So same finding as in our case. The purpose of the payments is to fund the loans. I'm satisfied on the fact there is a link between the payments and his employment. There might also have been a causal connection with the shareholdings, but I make no finding because it hadn't been pleaded. 2006, however, it's common ground that the money was paid to Mr. Wilson by way of a loan. He therefore has an obligation to repay the loans. HMRC have not established the loans are emoluments. Accordingly, the amounts are not earnings. The tribunal is saying the payments are being made to the trustee for the sole purpose of funding a loan. That's all the employee gets. Therefore, the correct approach is to consider the taxation of the loan. And the loans are not earnings, but they're taxable under Part 7A. So, HMRC have cited no authority to support their proposition that the payment to the trust must be treated as a reward for services. The situation is that the employer makes a payment to a third party, which is not in itself a reward for services, but is being paid in order that the third party will provide a specific benefit that is a reward for services. HMRC say, well, the later reward reverse characterises the original payment, such that the whole payment becomes taxable immediately. No support for that. We say it goes against Wilkins and Rogerson, we say it goes against Ford and McHugh, and it goes against the two tribunal cases. And like in Ford and McHugh, we say it's a counterintuitive outcome. If I may run through some examples. Let's use the facts of Apollo Fuels. That's at 860, the authorities bundle. We talked about this earlier, but I didn't go to it. So this is Apollo Fuels. The facts are at paragraph 4.
Sorry, which page is this?
So we're at 860 is the first page, and then one page over you have the start of paragraph 4, and then you have a recitation from the Upper Tribunal.
Yes.
So that's where you can find the detail, but if I can just summarise, Apollo Fuels is the employer. It bought second-hand cars to lease for full market value to specific employees. So Apollo Fuels buys a second-hand car, let's put some figures, say for £20,000, to lease to one of its, and it leases it for full market value. Of course, full market value of the lease is not £20,000, it's going to be the annual value of the lease. And it was accepted to be market value. What is the tax treatment? Answer, says the Court of Appeal, no tax. No charge under the Benefits Code because it's full market value. And there's also discussion, for your reference, of paragraphs 74 to 82, about whether the payment could have been earnings. It's not saying it is earnings, it's more looking at a sort of, is there a double tax or is there an exception point because it's already covered by earnings? Answer, no, there are no earnings. That sounds sensible. May I ask you please to read paragraphs 1 to 3 of the judgment on 861. So the revenues argument, they weren't trying to argue that the full capital value of the car was chargeable. They were just trying to argue that you had a charge under the benefits charge, which is a sort of proportionate charge, quite a small charge. Lord Justice Richards says that is counterintuitive in a case where you've given full market value. Okay, that was just for the small charge. Now let's tweak the facts. Let's say that Apollo Fuels had decided to run exactly the same arrangement, but decided it'd be better if the cars were owned and leased, not by the employer, but by a third party. Maybe a subsidiary, maybe a trust. So instead of buying the second-hand car to be leased, instead Apollo Fuels pays the subsidiary or a trust £20,000 to go buy a car, and then the subsidiary leases the car to the employee, for a specified employee, for full market value. The only tweak we've made is the payment. This is slightly picking up on Lord Justice Foxton's question yesterday. What difference should the payment make? HMRC say that fundamentally changes the taxation of the transaction. You, employer, have made a payment to a third party for the purpose of the third party rewarding a specific employee, providing a specific benefit to the employee. Therefore, they say, that imbues the payment for £20,000 to the third party with the character of earnings and it's immediately taxable. That is what they're arguing. Whereas if the employer did it themselves, there would be no tax charge at all. And everything Lord Justice Richards says in paragraph 3 doesn't just apply equally, it applies far more, because now we've got a charge on a full £20,000 rather than just an annual charge. The entire cost of the car. Let's take an accommodation example I referred to earlier. The company wants to incentivise a relocating employee. It pays £1 million to a sister company or a group company to purchase a house, which the employee can then use for 5 years. Maybe they don't pay rent, maybe they have to pay market rent. As an incentive, i.e. a reward for them carrying out their duties. HMRC say, ignore the benefits code on accommodation benefits provided. Ignore the fact that the benefit you get is, say, only 5 years, and it might be full market rate, in which case you wouldn't have a charge at all. You are taxable on the full £1 million payable to your sister company, or a trust, or whichever, any third party. Even though if the employer had purchased the house themselves, the revenue would accept, if it was full market rate, they wouldn't have a charge at all. Or if it was there was no rent or a low rent, you would look to the benefits charge and you would have a charge on the accommodation under the benefits charge. That cannot be right. It is not right. It is counterintuitive. The correct approach in those specific facts, i.e. we've got a payment made to provide a specific benefit, is to look to the tax treatment of the benefit. Different considerations apply in cases like Rangers or Tough Glaze, where the payments are remuneration and they're made to sub-trusts. And then you can add in the fact there are loans which are never going to be repaid. More permanent, so the benefit, because of the sub-trusts, is that even when the loan's repaid, it's all going to inure permanently for the employee or for people they choose. That's don't pay me, pay our tag. May I just take a moment before I move on? Those are the respondent's submissions on ground 2, on the redirection argument. As feared, in the interest of time, I'm now going to jump to my fourth part, which is to look at the first tier's decision and the upper tribunal's decision, and then I will use whatever time I have left to deal with ground 3, which is the loans. I think you already have my points on loans. I think you can see where we're going.
We're content with that.
So I'm going to address the first tier's reasoning and then the upper tribunal's decision. And then, of course, in addressing the first tier's decision, I'm addressing revenues ground 1. As a recap, at the outset of my submissions, we looked at divorce, we looked at sections 12 and 13 of the TCA. In assessing the first tier's decision, the primary question for the upper tribunal is there an error of law somewhere in the decision? If so, it had a broad discretion to set aside the decision, the approach being in divorce to ask whether the error of law might have made a difference. Not would have made a difference, might have made a difference. And the questions for you, I respectfully submit on appeal, are, is there an error of law somewhere in the decision, in the FT's decision, to the extent that's still disputed? If so, was the upper tribunal entitled to conclude that the error might have made a difference? I could no reasonable upper tribunal have come to that conclusion. Given how low the threshold is, we say revenue cannot meet it if we find an error of law, given the terms of the first tier's decision we're about to look at. The headline point on the first tier's decision is that its reasoning led to a conclusion that in the vast majority of cases, a loan would be earnings if it was paid as a reward. As I said, Mr. Waldegrove did not seek to defend that before the upper tribunal. He didn't seek to defend it before you yesterday. Mr. Ghosh accepts that the first tier asked itself an irrelevant question, which is also an error of law. I'm going to take you through it anyway. And in a sense, to a certain extent, you will need to plug in some of my submissions, I'm afraid, on part 3 as well to this point. My understanding is that revenue accepts there are errors of law in the first tier's decision. What they challenge is the exercise of discretion and the materiality. Those are very different arguments.
I didn't understand, I'll be corrected if I'm wrong, I didn't understand in yesterday's submissions that the appellant was challenging the exercise of discretion. They do challenge the materiality point.
That is the exercise of discretion. Sorry, well, that is the exercise of discretion because...
Not sure it is. But that's a point in your favour. I don't think I don't think you need to worry about. Don't worry about discretion unless they say I'm wrong. What you've got to focus on is whether the upper tribunal erred in deciding that the error of law by the FTT, if there was one, was material. And you've already given up your headline point on that. and you're going to develop that now. But that's what you need to focus on.
You are contending, as I understand it, that it's enough that it was reasonably open to an upper tribunal to conclude it was material.
So step one.
As opposed to that being a question that we have to decide, and at the moment I will
Precisely.
need some persuading on that.
Oh, okay.
So, yes, what's put against you, the most obvious way to put it is what's put against you is that that passage is obiter and therefore it wasn't material.
An error of law that is not material is said to be obiter. Starting point, there is still an error of law in the decision. So we're
Yes,
in
but the guidance,
section 12.
Okay, but the point is that the guidance in de Gorse doesn't give an untrammeled discretion.
Says it's a
There's
broad
guidance
discretion.
that in de Gorse which potentially affects the exercise of that discretion. So I think you might
I'm not saying
definitely to hear you on the obiter point.
I'm going to.
Maybe focus
My
on that.
submission, I think maybe this is the time to make it. I mean, I'll make it, obviously I'll ask you to agree with the upper tribunal, but my sort of alternative, maybe primary, is actually the test is discretion, because what you saw in de Gorse, it says it's a broad discretion. The decision of the upper tribunal when deciding whether to exercise its discretion, it must apply the materiality threshold. And it's for the upper tribunal to review the first tier decision. And I say that given that's an exercise of discretion, albeit applying a particular principle, that you would apply the threshold of exercise discretion to the upper tribunal's decision of whether or not the error of law might have made a difference. I say that is the correct approach. I would also say that given it's such a low threshold, even if you were to decide this de novo, that it is clear that it might have made a difference. That is where, picking up on the discussion earlier, you might have those points about respect for the upper tribunal and looking at the upper tribunal's decision on its own terms. It is for the upper tribunal to decide whether or not it sets aside the decision ultimately. And unless there's an error of law would be wrong principles, no one's suggesting that, upper tribunal applied de Gorse, or the discretion threshold. I say respectfully, that this court should not interfere, should not redo the exercise. Otherwise, we just keep on going up, re-looking at the first tier decision every single time and working out what the upper tribunal said. The question of whether to set aside the decision, if there's an error of law, which we say there is for the upper tribunal, section 12. But I also submitted, obviously, is material, meeting that low threshold. So that's what I say on what the correct approach is. Before we launch in, there's been some suggestion that the submissions before the first tier were limited to whether or not the payment to the trust was earnings. They were supposed to be so limited, but in fact the revenue's oral submissions did stray quite heavily onto the loans. I'll just show you two examples of that in the supplemental bundle, please. It's the very final page of the bundle. The topic, you've got 4 pages there in front of you from the closing submissions of the revenue for the first tier. The topic is CIA insurance, and it's internal page 94, starting at 16. Mr. Waldegrave is talking about the submissions that Mr. Ghosh made in CIA. Then Judge Popper says, sorry, if there's a real repayment. Mr. Waldegrave, well, the point of the principle supposed to be emerged to CIA is there a real payment obligation in relation to a loan, then there's no earnings. So already we're straying onto, is the loan earnings? And then we get Popwell, Judge Popperwell, Mr. Waldegrave, Judge Popperwell, yes, yes. I mean, you're asking me to view the fact realistically and say effectively that a combination of the contributions to the EBT and the loan back, by loan back, loan to Mr. Currell, or loan back to the company, which put the money in the hands of Mr. Currell to do what he liked with, okay, that's effectively the composite arrangement, means Mr. Currell was getting was remuneration. Confirmation, that means he gets his £800,000. So even though the issue was supposed to be limited to the payments, we can see the revenue submission straying onto the loans, and what's been developed before you as ground 3 and is now openly argued, which is, oh, the funds with the loan are put unreservedly at his disposal. You see a similar submission on the page before, page 162 of the bundle. It's internal page 25. At the bottom, it's the final, Mr. Warder, we say, viewed realistically, this does not involve any kind of sham. This was a device to put money in the unfettered control of Mr. Currell. We say this tribunal should prefer our view in working out how to characterise these arrangements. That's talking about the loan. So now we turn to the tribunal's decision. The respondent accepts, we start at page 124, that the tribunal starts off on the right foot. Paragraph 1. The question in this appeal is whether the appellant is liable to pay income tax under PAYE and NICs relating to the payment of $800,000. The FDT posed the right question, and although there's a bit of thinking about what the word payment means by the way we get to the end, we accept that ultimately it did answer the right question. It's how did it get there? Paragraph 9 of the decision. You've got a summary of the positions. And you've got paragraph 9 sets out the legislation. Paragraphs 11 and 12, we had some discussion of this yesterday. Parties confirmed the statement of Lord Hodge that in summary, income tax on emoluments or earnings is due on money paid as a reward or remuneration for exertion of the employee is the principle we should adopt. We agree. So the tribunal very much has in mind, if it can find remuneration, if the payment was remuneration, that's a straightforward application of ranges. That's why I keep saying this decision would have been much shorter if it had actually made that finding. 12, in our view, any benefit falling within 66(2)(b, we're told by the Upper Tribunal just ignore the reference to B, it's actually 62.2.2 generally, is also highly relevant in this case. We use the expression reward or benefit as a shorthand for the provisions of section 62. So every time we see reward or benefit, we need to read earnings within section 62. Paragraph 14, the issue is correctly stated. Once again, I say it's about the journey, the FD and the reasoning. We then have the submissions. We can pick up these at page 139. We've already looked at sort of the findings. It is clear the focus of our inquiry must be to establish the reasonable substantiation reason why the payment was made. As mentioned above, if that payment was made as a reward or benefit, then it is earnings, the determinations must stand. It's equally clear that we need to look, effectively it says need to look at all the facts. 24. We start therefore by looking for the reason the company made the payment, and therefore need to look at why the EBT made the loan. And then there's a reference to Marlborough. Paragraph 29 is the start of the discussion of why the payment was made. We've already looked at that. Why was the payment made? The payment was made in order to make the loan. So in this section, 29 onwards, we have a factual question being asked. Why was the payment made? The payment to the trust. Answer, finding, the payment is so that the loan can be made. Been over that. Then you get the further question. And it starts at, it goes to 32. So it's on page 143. The first tier reiterates the purpose, the substantial reason for the payment is the fund of the trustee in order to make the loan. and it doesn't accept the other findings, it says this is all pre-wired, then you get a new section. Was the loan a reward or benefit? Reward or benefit means earnings within section 62. Paragraph 36. It is our view that a genuine loan of money with real repayment obligations can, as a matter of legal principle, comprise a reward or benefit. And in this particular case, the loan was a reward or benefit. So read with the additions, every time we see a genuine loan can, as a matter of comprise earnings within section 62. And in this particular case, the loan was earnings within section 62.
Subject to finding that it's, because they do at 37 say if a further condition is satisfied, don't
They say provided it's a reward for employment. So if you had a loan and it had been found the loan was because you're a shareholder, then obviously that wouldn't be. But in this case, they find loans in principle can be earnings provided you've got the appropriate connection with employment. It's not from something else.
And this loan was a reward or benefit.
Yes. So it says this loan was earnings within section 62. It doesn't stop there. Then you get reason, and the reasoning includes matters such as the loan being sought by a borrower, the fact that funds might be used to create a profit by investing or saving a company. Mr. Currell might be given the loan as a beneficiary. Just to be clear, none of these points were actually discussed in detail before the first hear, because of course, as far as I was concerned, we weren't arguing about the loan. You didn't have any of the authorities, Apollo Fuels, O'Leary, Upper Tribunal in Murray. We didn't talk about those before the first hear. We only raised them before the Upper Tribunal because we weren't supposed to be talking about whether the loan was earnings. And this is where, give some understanding, the first hear is basically doing this without submissions. This is where it goes wrong. That leads to 37. So it goes further. It doesn't just say it can be. It says, in summary, our view is that a matter of law, there is nothing which prevents a genuine loan on commercial loans conferring a benefit. It is our view that in the vast majority of cases, in practice, such a loan will confer a benefit, benefit short for reward or benefit. And in the context of this case, the loan conferred a benefit. Its payment, the loan, therefore was potentially within the ambit of section 62. Whether
It's payment to MC.
Yes.
You might want to emphasise.
Yes. Sorry, yes, it's payment to MC to make it even clearer. Later, we're going to get a bit of confusion about where the payment goes.
Yeah.
Whether it was earning depends on the substantial reason for its payment. And then we get 44. So we've already looked at the other findings at 44. Thirdly, as submitted by Mr. Wardergrave, and as I have said above, a real loan with genuine obligation to repay does not, as a matter of law, mean it simply cannot be earnings. The inquiry is still the same. What is the reason for the payment of the loan? If it was paid as a reward or benefit for Mr. Currell for his exertions, then it is earnings, even if there's a genuine obligation to repay it. Rangers is authority for that proposition. Not quite sure where that last sentence comes from.
You would say that's just wrong.
It's just wrong.
Or they've misunderstood Rangers in the Supreme Court. It's not authority for their proposition. Whatever else it may be authority for.
Indeed.
It's not that.
We could point to individual lines saying there's errors all strewn throughout this, unfortunately. So I do have some sympathy because we weren't supposed to be arguing about this before the first year. We really were supposed to be focusing on just the payments. And that leads to... So as you can see, and we've already looked at the submissions, Mr. Wardergrave was trying to submit that the loan was placed unreservedly and therefore was earnings. We've looked and we've seen what the judge certainly understood from the transcript, what the submission being made was. So paragraph 37 and then 44 are the most obvious places to see the error of law. First, so now we're just identifying an error of law. The tribunal doesn't just say the loans can confer a benefit, it says they will confer a relevant type of benefit in the vast majority of cases. And therefore, the loan in the present case will be earnings if the reason it was paid as a reward for services. And as we will see when we get to the Upper Tribunal, the revenue did not seek to defend that bit of the judgment. They said it's all fact sensitive. They could not and did not defend it in the vast majority of cases, and they don't defend that before you. So at this stage, we see the first tier My lords, I'm very happy to sort of stop now. I'm about 3 or 4 minutes from getting to the end of the FTT analysis, so I'm in your hands.
Why don't you finish the FTT analysis and then we'll adjourn.
I'm very grateful. So far, we can see the tribunal has set itself a particular question, whether the loan is earnings.
That may.
Attention, please. Attention, please. This is the Incident Control Officer. An evacuation is in progress in the West Green building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Please continue normal business.
Attention, please. Attention, please. This is the Incident Control Officer. An evacuation is in progress in the West Green building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
So we've seen the errors of law in the earlier discussion. We've then seen the revenue submission articulated at 44. So at this stage, the tribunal has set itself a particular question whether the loan is earnings. We know how it's going to answer that. So it says not the payment to trust, but the loan. We know how it's going to answer that. It's going to say, well, the loan is a reward for services, and therefore it's earnings in this case. Paragraph 38 is where it starts that analysis. Why was the loan made? 44. And then we get a long discussion of why it reached that conclusion. Say, not really in dispute that an employee benefit trust giving a loan to a beneficiary, but that is going to be connected to reward for services. It's a long discussion on this. Then we get to the conclusion. This is it's on page 148. Before we do, let's just pause and remind ourselves of the primary findings. So the primary findings were that the reason for the payment to the EVT, in relation to that, at paragraphs 29 to 32, the FTT has not found that the reason for the payment was remuneration. It's found, nor that it's a substitute for remuneration or anything like that. It's found the payment is to fund the loan. Second, the tribunal has now asked itself what the reason for the loan was, and it's answered that at 38 to 55. It said the loan was to reward Mr. Currell.
Sorry, was
To reward Mr. Currell. The loan was to reward. Third, rather than follow all the case law like Rangers Upper Tribunal and holding that a loan is not earnings, at paragraphs 33 to 37, it's found that the loan can be earnings. Those are the 3 steps in its logic, and that is what you see at 56. We have found it was inevitable at the time at which the payment was made to the company, by the company EBT, that it would be paid by the trustee to MC by way of a loan. Now pause there. We've now got the payment being used to cover 2 things. The payment in and then the loan onwards. We have also found that it was more likely not that the loan was paid as a reward for the services to the company. It doesn't say the payment to the EBT was a reward. It doesn't find that. Third sentence, in our view, there is no legal principle which prevents a genuine money loan on commercial terms of a real repayment obligation for being a reward or benefit, i.e. shorthand for section 62. That's what it's found already. So those are its 3 building blocks. 57. In these circumstances, you add in, i.e. in light of the 3 points at 56, you add in it is our view that the payment, therefore, was paid by the company as a reward for services supplied by Mr. Currell to the company. It, therefore, comprises earnings, is thus taxable. So, in these circumstances, show that the conclusion has come from the 3 propositions, at paragraph 56. That means that the conclusion on whether the loan was earnings forms part of its reasoning and is material to the conclusion at 57. There's only 3 sentences, there's 3 points, and it says therefore. We also have some confusion as to what the word payment means at this stage, because we've seen at 56 it started to cover both. It cannot be said the conclusion of the loan is immaterial. It's clearly part of the reasoning that leads to paragraph 57. In fact, it's critical, given how the FTT identified the issue at 37 and 44 by saying the loan would be earnings if it was a reward for services. And if you have any doubt for that, we actually get confirmation for the final point over the page, which is paragraph 61, because the tribunal finds that it has to find that CIA and strategic branding are wrong. By parity of reasoning, it is argued that the substantial reason why the payments were made in the Baxendale Walker cases was to enable the trustees to pay the loans. But those loans were legally capable of being a reward or benefit, i.e. earnings, and we consider the reason for those loans was to reward the relevant individuals for their services. So it's the three steps in the logic again. Reason for the payment is to fund a loan, loan is a reward, therefore reward, i.e. earnings, loan is earnings. So there's an error of law, in particular the vast majority of loans point, which the revenue don't seek to argue. Further error in saying the loan in this case was earnings. We say, even if you consider the matter de novo, apply the divorce threshold, and in particular the interests of justice point raised by Lord Justice Henderson. The conclusion is that that error of law may have affected the final outcome. Not would, may. Very low threshold.
Right.
I'm grateful for the additional time.
Thank you. Yes, we will sit again at 2:05.
Court rises able.